This is a review of BLLE Chapter 8, Introduction to Contract Law. After reading the chapter, we should understand why and how contract law has developed, what a contract is, what the sources of contract law are, and how contracts are classified. You will often see the word contract used interchangeably with agreement, bargain, undertaking, or deal, but as you will find during the course of this module, a contract is significantly and legally different from an agreement. Before we get into all of that, what role do contracts play in modern society? Contracts should be one of the most familiar legal concepts in our society because it's kind of central to many parts of life, from politics to economics and even social media. The development of contract law contributed to the creation of our modern capitalism. Contract law serves to maintain incentives to exchange goods and services efficiently, to reduce the costs of economic transactions due to less negotiation, and alert contracting parties to the troubles of the past by making for easier planning. Contracts essentially describe a relationship between two parties. It defines what they can expect, the scope of their work, and what happens when the parties break up. In contract law, we call this a breach. Contracts fall within the state law domain, which means that they are governed by state law. Depending on the nature of the contract, the term contract and its requirements may be defined by case law or by statutory law. Each state has case law and statutory law that applies to contracts. If the subject matter of a contract is or relates to services, real estate, employment, or insurance, then they are governed by state case law. If the subject matter of a contract is or relates to the sale or lease of goods, secured transactions, investment securities, or anything covered by statute, then they are governed by state statutory law. Case law is established by judicial cases. The restatements are a set of legal treatises that seek to inform judges and lawyers about the general principles of common law. Contract law is made in common law courtrooms by individual judges as they apply these rules. The American Law Institute, or ALI, has drafted the first restatement of contracts in 1932 and revised that with the second restatement of contracts in 1979. A second source of contract law, of course, would be statutory law. Laws that are created by legislative enactments are termed statutory law. Domestically, contracts fall within the state law domain. Depending on the nature of the contract, the term contract and its requirements may be defined by case law or statutory law. Case law is established by judicial cases. The restatements are a set of legal treatises that seeks to inform judges and lawyers about general principles of common law. It is pretty much one of the most and best recognized and frequently cited legal treatises in American jurisprudence. Contract law is made in common law courtrooms by individual judges as they apply these rules. In the world of contracts, the American Law Institute has drafted the first restatement of contracts in 1932 and revised that with the second restatement of contracts in 1979. A second source of contract law is statutes. Law created by legislation is termed decisional law or statutory law. The Uniform Commercial Code is something pretty close to legislation, but it is not, however. The UCC is a national uniform model code that most states have adopted in one form or another, but the UCC was not enacted by the United States Congress, so it does not have the effect of national legislation. In those states that have adopted it, the UCC forms state statutory law. In either event, both the Restatement Second of Contracts and the UCC views contracts as being the mechanism that creates a binding obligation. The Restatement Second of Contracts in Section 1 defines a contract as a promise or set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes as a duty. Similarly, the UCC defines a contract as the total legal obligation which results from the parties' agreement as affected by the UCC and by any other applicable rules of law. All in all, a contract is a binding and legally enforceable promise. Just remember that not all promises are or form contracts, but all contracts are formed by at least one promise. As we will see in the forthcoming chapters, a contract has a number of components or requirements, including mutual assent, consideration, legality of object, and capacity. But as a general rule, Contracts do not have to be in writing. Oral contracts are just as enforceable as written ones, even though they may come with enforcement obstacles. Later, we will address an exception to this rule called the statute of frauds, which specifies when certain types of contracts have to be in writing. Further, Article 2 of the UCC governs contracts if and only if the contract is for the sale or transaction of goods. UCC Article 2 defines goods as all things movable at the time of identification to the contract for sale other than money in which the price is to be paid. Case law and statutory law apply to domestic contracts. However, what if we are dealing with an international contract for the sale or transaction of goods? If we are working in the international arena and we have a contract for the sale or transaction of goods, then that contract may be governed by international law pursuant to the Convention on the International Sale of Goods, or CISG. International law includes bodies of law that are established by or adopted by customs or treaties and recognized by other nations as being binding in their relations with other signatories. The effect of international law is to produce uniform federal law. The CISG is very similar to the UCC, and it can be described as the international version of the UCC. However, there are notable differences between the two. First, the UCC requires that contracts have consideration to have binding effect. We will define consideration in the next chapter. However, the CISG has no consideration requirements. Second, the UCC has certain writing requirements called the statute of frauds, and the CISG has no such requirement. Third, the CISG preempts the UCC because the former is national law via a treaty, and the latter is state law. Preemption refers to when federal law will trump state law pursuant to the United States Constitution's declaration that the Constitution, federal laws made pursuant to the Constitution, and treaties made under the authority of the United States Constitution constitute the supreme law of the land. The fourth difference is that the application of the UCC is mandatory when the conditions of having a domestic contract for the sale or transaction of goods is met. But under the CISG, parties to an international contract are able to choose to have their contract governed by a different body of law. And lastly, the CISG does not apply to contracts for the sale of 1. Ships, 2. Aircraft, 3. Electricity, 4. Consumer goods, which are goods bought for personal, family, or household use, or 5. Where the predominant purpose of the contract is the provision of services and the goods are furnished incidental to those services. There are 4 broad classifications of contracts. First, a contract can be classified by explicitness, which is the degree to which the agreement is manifest to those not a party to it. The explicitness of a contract may either be express, implied in fact, or implied at law, or quasi. A contract may be express, wherein the terms of the contract may be oral or written, but the terms are spelled out directly and the parties must be conscious that they are making an agreement. A contract may also be implied or inferred from the actions of the parties. An implied contract occurs even if the parties have not discussed the terms, if it is clear from the parties' conduct that they intend to have a contract. For example, when a patron of a cafe asks for a sandwich, there is an implicit agreement between the parties as to the price of that sandwich. Or take this example. Let's say a company hires a contractor to landscape for the entire summer. The contractor landscapes for the first 3 weeks of the summer and gets paid on Friday morning each time. On the 4th Friday, the contractor landscapes, but the company refuses to pay. Under these facts, the law will infer that there is a contract between the company and the landscaper to continue to perform and get paid for those services, irrespective of the fact that the parties had no writing to evidence their agreement. This is an implied, or sometimes called an implied in fact contract. The company would be obligated to pay the contractor because the contractor performed their part of the bargain, there was an agreement based on both parties' prior conduct, and the company was enriched by the contractor's performance. Third, a contract may also be implied at law, or sometimes called quasi. Here, the law will imply the existence of a contract, impose a duty to perform that contract, and even enforce a contract against a person's will, where the circumstances are such that without this remedy, one of the parties would be unjustly and unfairly enriched at the expense of the other party. In such a situation, the existence of a contract does not depend on the intention of the parties to enter into an agreement. Let's look at another example. Let's say Miss Brooks is eating dinner at a ritzy restaurant in downtown Los Angeles and happens to choke on her food. Dr. Oz, sitting nearby, observes Mrs. Brooks choking and rushes over to perform the Heimlich maneuver, thereby saving her life. If Dr. Oz later sends Miss Brooks a medical bill for services rendered, Miss Brooks is obligated to pay Dr. Oz even though she had no intent to enter an agreement with him. This is because Miss Brooks would otherwise be unfairly enriched by Dr. Oz's services. To avoid unjust enrichment here, the law will find an implied at law or quasi-contract to require Miss Brooks to pay the fair value of the services she received. Contracts may also be classified by the mutuality of promises that are given. If both parties make mutual promises, then the contract is classified as bilateral. In a bilateral contract, the promisor and the promisee make a promise. Or, otherwise stated, both parties to the contract make and receive a promise. Each party pledges to do something, and each is in receipt of a pledge. For example, let's say Miss Cole promises to wash Miss Flores' car, and in return, Miss Flores promises to pay Miss Cole. This forms a bilateral contract because each party makes a promise in exchange for a return promise. However, if one party performs an act in exchange for the other party's promise, then the contract is classified as unilateral. For example, if I lose my dog Apollo on a morning run in the park, and I offer a reward for Apollo's return, a unilateral contract will be formed if my neighbor has knowledge of my offer and performs the task of returning Apollo. Contracts may also be classified by the degree to which it is binding or enforceable on the parties. A contract may either be void, voidable, unenforceable, or enforceable. First, a contract is void if it lacks a legal element. Try to think about void as being a legal nullity and having no legal effect whatsoever. It is an absolute nullity. The law treats void contracts as though they never existed or happened. So let's do another example. If Mr. Eklund agrees to commit a crime in return for Ms. Aceves' payment of money, as we will find, this contract is void because of illegality. Second, a contract is voidable when it may become unenforceable by one party, but it can still be enforced by the other party. Voidable contracts maintain their validity and effect until the party who can void it, in fact, does void it. In a later chapter, you will come to understand what conditions render contracts voidable. One of those conditions is infancy. So, for example, a minor has the power of contractual avoidance when they enter into a contract with adults. In this situation, the adult may not enforce the contract against the minor if the minor refuses to carry out the bargain. Third, an unenforceable contract is one in which some rule of law bars a court from enforcing. So if there is a statute of limitations on when a party can bring a cause of action for breach of contract, and the statute has run, i.e. expired or lapsed, then the court cannot enforce the contract because it is unenforceable. And then lastly, an enforceable contract is one in which all the elements are met and satisfied to have a contract. And lastly, a contract may be classified by the degree to which it has been completed. This classification considers whether the contract is yet to be performed, i.e. executory, or whether the obligations have been fully discharged by one or more of the parties, i.e. executed. So an agreement that consists of promises that have not been carried out is called executory, and they do not lose their enforceability on the basis of not yet having been executed. This concludes our review of this chapter. Great job, guys. If you have any questions, please feel free to send me a message in Canvas or ask me after class.